I'm going to call this hearing to order.
These things.
And I want to introduce first my colleagues, my counselors, Counselor Tara Jacobs, Counselor Paul DePaula, and Counselor Chris Iannella.
Good afternoon.
And I'm Marilyn Petito DeVianney, your counselor, and I'm very honored to be presiding today. So I welcome you all. Now, I first have some rules that I say before we start. I ask all cell phones to be put away, and that includes counselors to put the cell phones away, because this is a very special day, and we want to show respect to this nominee. Having said that, we only have 3 councils here, and
I'm here as well, Marilyn, on Zoom.
Joe Ferrero's here on Zoom as well.
who is that?
Terry Kennedy.
And Joe Ferrero, both here on Zoom.
Okay, all right, and we have Counselor Barrera somewhere out there in Zoom.
And Terry Kennedy.
But he's not here either. Where are you?
They're both on Zoom, Councilor Terrence Kennedy and Councilor Joseph.
Okay, so thank you. And so here present are Counselor Iannella, thank you, and Counselor, again, DePaula and Counselor Jacobs. So having said that, and I am assured that these councils will stay till the end in respect to the nominee and to hear all of your testimony. So having said all of that, now we'll begin. I welcome you. And I first want to read the letter from the governor. Dear councilors, I am pleased to nominate Keren E. Goldenberg to the position of Associate Justice of the Superior Court. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Sincerely, Maura T. Healy. So why don't you introduce the people who came here to support you?
Absolutely. Thank you so much. The first person I want to introduce is Laura Weinstein, my wife. The others who are here are all very talented lawyers who have supported me over the years. Kayla Wheaton, who was an associate in my office for 6 years.
Welcome.
Chris Powell, my first friend when I went to law school. I met him on the first day. Joanne Daly, Julie Olson, Allison Cartwright, Connie Tran, and Linda Dantas, who all have worked or currently work at the Committee for Public Counsel Services.
Okay. As I said before we started, I had an ear infection, not contagious, but I still haven't got full hearing. Doctor said it's coming back, so I'm having a little trouble hearing. So I hope everyone will speak loudly. So having said that, I'm going to start with your witnesses. So you have given us 2 witnesses, and your first one is Jean Daly. And why don't you sit beside the nominee? Thank you.
Joanne Daly.
Good morning. Good afternoon. Yeah.
Good afternoon. My name is Joanne Daly. I am an assistant federal public defender for the districts of Massachusetts, New Hampshire, and Rhode Island. Before joining the federal defenders, I was with the Committee for Public Counsel Services Public Defender Division for nearly 15 years, starting in 2004 as a staff attorney with the Lowell Superior Court Trial Unit, and then serving as attorney in charge of that unit from 2009 to 2018. I also served as the interim deputy chief of the CPCS Public Defender Division in 2012. Prior to joining CPCS, I was a staff attorney with Legal Aid Society Criminal Defense Division in Manhattan. And I am here to enthusiastically and wholeheartedly support and recommend the nomination of Attorney Keren Goldenberg to the Superior Court. I met Keren when she started at Legal Aid in 2003, but we didn't get a chance to work closely together until she came to CPCS Lowell in 2004. And it was there that we worked together for over a decade. I've known Keren now for 20 years, 10 years at CPCS and 10 years since she entered private practice. And I'm really lucky to have been in a position then and now to see her absolute determination, compassion, intelligence, her dedication to the rule of law and to our system of justice, her compassion for her clients, especially those dealing with mental health and substance use issues, her intellect when it comes to not just knowing the law, but knowing her cases, knowing the science that comes along with many of our cases and becoming a quasi-expert in every case that she ever tackled. She is a force to be reckoned with in the courtroom, but also highly respectful of every single person who walks into the courtroom, whether it be the judge, the prosecutor, court officers, custodial staff. She is a professional and she will be an absolute benefit to the bench, and the Commonwealth will be extraordinarily lucky to have her as an associate justice in our Superior Court.
Any councilors have any questions? No questions. So tell me how long you've known this nominee?
Since 2003, so 21 years, nearly 21 years.
Right. So what would you say that the best quality she's bringing to the court?
So many. I would say compassion is such a needed and a necessary quality as a judge, dealing with individuals who are coming before them, some dealing with the most traumatic and difficult experience in their life, whether it's a criminal defendant, a party who's been aggrieved in a civil context, a victim of a crime. Her ability to get to know not just the individuals who she interacts with, but understand their story. When she represented individuals as a public defender and as a private attorney, her ability to advocate for them, to understand their needs. And as a judge, I believe she will apply that level of compassion in understanding all of the parties who appear before her, and in advocating for our system of justice, which calls for compassion at all times.
Very good. I want you to know that the councils really listen to the witnesses, because we look for what you know about this person, because you have worked with her, you've known her professionally and lots of times personally. So it does mean a lot to us. So thank you. It was very important to us to hear you. So no questions. How about in Zoom land? Anyone got any questions?
You're good.
They disappeared. Thank you.
Thank you so much.
And your next witness is, let me see now, Connie Tran.
Connie Tran.
Welcome.
Thank you. My name is Connie Tran. I am a criminal defense attorney. I'm honored to be here to tell you, each of you in person, why Attorney Keren Goldenberg should be confirmed as a Superior Court Justice. I first met Keren in 2012 when I was a freshly minted public defender, navigating the nerves of my new role. If you could picture a room filled with 65 eager yet apprehensive new law graduates, Keren was already a seasoned public defender and at the core of CPCS's training unit at the time. In this sea of uncertainty, Keren stood at the helm with authority and grace as a maestro, guiding us through trial skills workshops, such as cross-examinations, opening statements, and technical rules of discovery. Her teachings were transformative, shaping us into more confident and capable advocates. Week after week in this training, Keren ignited a passion in us for the practice of law, helping us find our voice and our poise when faced with telling the most challenging and uncomfortable stories in public forums. When Keren left CPCS in 2016 to forge her own path, I had the privilege of experiencing her vision and skill up close. During my interview for an associate position at her firm, I was inspired by her example of determination and innovation. Although I was not selected for the position, Keren's interest in my development as a young lawyer did not waver. She has been a compass for my career since that time. The following year, I ventured out on my own to start my own practice, carrying with me the lessons learned from Keren's example. In Keren, I see a role model. She is an attorney who embodies boldness, empathy, and intelligence. These are the qualities I strive to emulate as I navigate my career. Keren is generous with her time, her attention, and her teachings. In her future role as Judge Goldenberg, she will ensure that everyone in the courtroom feels seen and heard. Keren's knowledge of the law is vast. Her understanding of the law is constantly evolving. She immerses herself in the complexities of in the fields of forensic science that dominate the modern courtroom and tend to intimidate most lawyers. With academic rigor, Keren approaches hyper-technical aspects of the work, such as statutory construction, DNA testing, and statistical analysis, and she does not shrink or shy. Yet, Keren remains deeply grounded in the practicalities of her clients' lives, consistently considering the real-world impact of her choices. She possesses the optimal combination of intellect and compassion, viewing the human experience through a multi-dimensional lens. She has shared with me stories working in Lowell in the Merrimack Valley of representing young adults who are children of war-torn places like Cambodia or Vietnam, or gang and poverty-ridden places like El Salvador or Haiti, struggling under the weight of their parents' trauma as well as their own. In Keren, I witness a profound commitment to understanding and addressing the braided roots of human suffering and decision-making. Keren challenges biases. She scrutinizes all angles, race, gender, societal lines, turning them over and over to reveal deeper truths. It is my great honor today to sit before you and advocate for Keren Goldenberg's confirmation and personally recognize the exceptional qualities she brings and support her appointment. Thank you.
I love your enthusiasm, even though you don't want to leave, right?
Yes.
No, thank you for that. I'm going to ask my councilors if they have any questions for this nominee. Councilor Aiello? No one else? Okay. Well, now, how many years have you been associated with this nominee? And tell us how they happened.
I first met Keren in 2012 when I started a new lawyer training as a new public defender. So it has been about 14 years now. Right? Yes. 12 years. So, sorry, I can't, 12 years.
When you think of her, what is the best quality that she's bringing in this position?
Keren is open-minded. That is the best quality that I see in her. When I watch Keren from afar and up close, one of the things that I most admire in her is her ability to see the forest and the trees, and for her to challenge her own concepts of understanding, trying to prove herself wrong to try to get to the right answer. So that would be the quality that I most admire in Keren.
Well, thank you. I appreciate it because I know it's professional, but there is a personal touch here that you know her that way. So that means a lot to us. So thank you for testifying.
Madam Chair, can you hear me? Terry Kennedy.
Any questions from the Zoom people? I hear a
Madam
voice.
Chair?
It's Terry, Council Kennedy.
Councilor Kennedy has
Can you
questions.
hear me? Connie,
All right.
it's good to hear.
I'm rec-
Terry Kennedy, if you can hear me?
Excuse me, I'm recognizing you, Council Kennedy.
Thank you. Connie, it's great to see you. When you said that you were a criminal defense lawyer, you left out the fact that you were a superb criminal defense lawyer.
Thank you.
That does a great job. And I just wanted to comment, we're going to be waiting for your application very shortly,
Thank you.
hopefully.
Thank you. Do any councils have questions? Questions? Thank you very much.
Thank you very much.
Appreciate it. Having concluded the witnesses, is there anyone here that would like to speak on behalf of this nominee? I welcome you. Okay, hearing none. Is there anyone in opposition? Hearing none, then we will go to you, and now it's your turn for your presentation.
Thank you. I don't think I can beat what was just said about me. Thank you very much to my witnesses. I would like to thank Governor Healy and Lieutenant Governor Driscoll for honoring me with this nomination. Chief Legal Counsel Pete Scott Reed and Deputy Legal Counsel Derek Hesselheim for their support in this process, and of course, for bringing my application to the governor's desk. Thank you to the Judicial Nominating Commission for carefully considering my application among many others and sending my application over to the State House. And thank you most of all to all members of the Governing Council for reviewing my application, for meeting with me, asking insightful questions, and for your consideration. And final thanks to Valerie McCarthy, who makes this all happen. Members of the Governor's Council, you have all had a chance to review my application and learn about my legal career. I would like to tell you about my upbringing and influences to help you better understand me as a person. I grew up in Toronto in a household consisting of me, my identical twin sister Maya, and my parents Andrew and Aviva. My sister and I were born in Canada several years after our parents immigrated from Israel. We formed a tight nuclear family as our extended family lived abroad, although we visited often. My childhood was happy. Both my parents were college professors, my mother an architect, my father in engineering. My mother scheduled her classes very early in the morning, so she left before us, and my father would get us off to school. She would be home when we got home from school, and we would all sit together for dinner, talking about the day's events and whatever else came to mind. If my sister and I got our homework done on time, we could watch The Cosby Show at 8 p.m. I felt loved and safe, encouraged to explore the world and to be ambitious. That stability gave me a sense of grounding. I had the type of childhood that every child should have. My wife Laura and I are trying to give our daughter Noah the same kind of childhood. We sit down for dinner every night, and at some point, I will implore Noah to talk less, eat more. I hope she grows up feeling the same way about her upbringing as I do about mine. In my professional life, my client's upbringing stands in stark contrast to my own. A common thread is that so many of them have experienced more tragedy and suffering than the human heart can bear, often at a young age. They turn to drugs, they hurt themselves, they hurt other people. Some spend their lives cycling in and out of correctional facilities. I have always looked at my clients and thought about how differently they may have turned out if they had a childhood more like mine. I think about where I might be if I had endured what many of them have been through: neglect, abuse, trauma, racism, and unmet medical and educational needs. One's personal history is not an excuse for committing crimes, especially when the crimes hurt others. But it is important to know the full person and to understand what brought them to that place. As a lawyer, I have sought to introduce the court to the full person. I always appreciate the judges who gave my clients' personal circumstances fair consideration. One of those judges was Paul Chernoff. Judge Chernoff passed away 2 weeks ago at the age of 85. I would like to tell you about Judge Chernoff so that you understand the type of judge that I aspire to be, if confirmed. I was a staff public defender in Lowell for almost 11 years, and Judge Chernoff sat regularly in the Lowell Superior Court's criminal session. We saw a lot of each other. He was kind, thoughtful, and compassionate. He treated every litigant, lawyer, court staff member, witness, and victim with a sincerity and an open heart. No matter how contentious a case, he managed to make everyone feel heard and to rule wisely. Rarely did anyone leave the courtroom angry, even when they didn't get what they'd hoped. I attended Judge Chernoff's funeral service. There were 60 or more judges in their judicial robes. They formed a procession to enter the synagogue sanctuary, and it was beautiful. There were uniformed court officers standing by the doors in attention. It was a meaningful tribute to someone who touched so many people's lives, both on the bench and off the bench. Judge Chernoff was well regarded for his approach to sentencing. He would say that sentencing was the hardest part of being a judge, and I suspect that I will feel the same way. He explained that he strove to impose a sentence that fulfilled the goals of sentencing, but wasn't so harsh that it deterred those goals. He successfully accomplished that balance, and I will look to his memory for guidance if I receive the honor of being confirmed as an Associate Justice of the Superior Court. I have told you about how my clients' lives have been impacted by their interactions with the courts and how one particular judge can change lives. But I have also felt the impact of judicial rules in my personal life. The SJC ruled in Goodrich v. Department Health that there was a constitutional right to same-sex marriage. This was a monumental decision for everyone in the LGBT community, including me. Beyond the legal rights that came with a recognized marriage, it was a big step forward in making same-sex relationships seem normal. But despite being able to marry, our rights were limited to state law. Laura is a US citizen, but she could not sponsor me, her Canadian wife, for permanent residency because our marriage was not recognized under federal law. This changed in 2012 when the United States Supreme Court struck down Section 3 of the Defense of Marriage Act in United States v. Windsor. Only then did we have full equal rights under the law, and I am now a US citizen. The Windsor opinion was issued in 2012, and we celebrated with our daughter Noah, who was 1 year old at the time. Several months after Noah's birth, Laura adopted her. Second parent adoption by a same-sex parent has been permitted and legally secured in Massachusetts since 1993, following the SJC's ruling in adoption of Tammy. From a practical perspective, the adoption gives security to our daughter, who has a second parent with equal legal standing to me. On an emotional level, it means much more. Noah goes to a school where there are other kids with two parents of the same sex. It's not a big deal to her teachers, or to her friends. I have told her that a child with same-sex parents used to be a big deal, and she can't believe it. This path started with a judicial opinion, and society followed. And this is the power of the courts. I hope my personal statement helps you better understand me as a person and the type of judge that I aspire to be. Thank you for this opportunity to speak, and I welcome your questions.
Thank you. Any questions?
Yeah, just a few, very good presentation. I really enjoyed it. Compelling. It was really good. I like the fact that you're a family person. I think it is important. They don't do it as much today as opposed to years ago when all the kids sit around the kitchen table and talk. I think that's a good thing. Because of work schedules is more difficult. I understand that. You talked about alcoholism and drugs. I've always been a strong advocate that judges should have some understanding about addiction and mental health issues. Same thing with the parole board. That's one thing that traditionally we've had people on the parole board who used to be assistant DAs and former assistant US attorneys. I don't like that. Because what do? They try the case all over. It's not about that. It's about rehabilitation. Give me your sense, the difference of how you would deal between incarceration and rehabilitation.
Rehabilitation is very hard to accomplish in custody, especially if a person has been traumatized. But still, sometimes incarceration is necessary. If I have somebody on probation, I recognize that relapse is part of recovery. When I was a new lawyer at Legal Aid, I remember a social worker telling me that just because my clients relapsed 39 times after drug treatment, it doesn't mean that it won't stick on the forehead. And that's the attitude I take with my clients, and it's how I represent them in court when they've had a relapse.
I couldn't agree with you more. I used to do criminal law. And if somebody, they take a urine test and they fail it, and they got a probation surrender, some judges, okay, you're going away. Like you said, you're gonna screw up. On the way to recovery, you're not gonna be perfect. And I like that answer. I mean, that's part of recovery, that's right. Part of getting better. So no, that's good. What do you do? It may not happen as much as in the district court, but a pro se, someone comes in pro se. Not represented by an attorney, criminal case, for whatever reason. They wanted to handle the case themselves.
Criminal defendants in superior courts are an interesting group, because unlike in district court where it may be a suspended license, you're facing very, very serious consequences. I'm very uncomfortable with a person representing themselves on an indicted felony. I would try to convince that defendant to accept counsel. If they are not indigent, maybe we can have, maybe they're partially indigent and can contribute to the cost of a lawyer. And if nothing else, I would appoint standby counsel, which is not an appointment that lawyers particularly enjoy. I've done it. But it's essential that somebody is there looking over the client's shoulder and making sure that they're not doing things that are detrimental to their best interests.
I'm not familiar, like I said, I don't do criminal. But I know it doesn't happen often. But once in a great while, I want to handle this case. I want to try the case myself. You can still have what you call standby counsel. And
the standby counsel, oh, sorry.
that's okay. Is she doing anything? The defendant, no, I'm doing it myself. So, what do you do in that situation?
The person has a right to represent themselves. The standby counsel is often sitting there, gripping the table with notes and trying to pass things over to the client. But it's up to the client whether they want to accept that assistance. I have found, I've never been standby counsel at trial, but often the pro se litigants, on the morning of trial will suddenly see the light and realize that maybe this is over their head. But some people represent themselves, and often the outcomes are not great.
What do you do? Well, let me backtrack. Everyone, I ask this question not often, but do you have a temper? Everyone says, not me. It's almost no judgment. Massachusetts has a temper. Everyone has some temper. Maybe a little. How would you describe your demeanor?
Most of the time I'm like this.
Anyway.
Yeah. She's probably a better person to ask. Most of the time I'm like this. When I get irritated, I might get a bit of an edge in my voice, but I don't yell. I don't humiliate, and I would never do that in the courtroom because I don't like to punch down, and a judge reprimanding a lawyer is really punching down. So I will leave the bench if I'm irritated, take a few minutes. I might send the clerk to give the lawyer a little advice, but I don't want to be on the bench reprimanding a lawyer, especially if their client is there.
I totally agree. And do you give any leeway to someone who you think is less experienced, you know, assistant DA, and you can tell he is, they haven't been around, or criminal defense lawyer, what do you do in those situations? I know you have to let them try the case, but you know, help them out, you talk to them afterwards, politely, what do you do in this situation?
That's a tough one, because I think that the judge should not be putting their thumb on the scale.
I don't think that, I think talking, the case is resolved. Oh, and then you say.
Yes.
You did a great job.
Yeah.
But, you know, I can wait, you did a great job, don't have to go there, something like that to help them out.
Give it to him.
Well, I mean, I've done a lot of that in the training capacity, so I would certainly offer the lawyer the opportunity to come to my chambers and talk to me about it. Actually, Judge Brieger, I've tried quite a few cases in front of her. That's something she does.
Oh, really?
She would invite a prosecutor and defense attorney to her chambers. She would tell us what the jurors told her. And it wasn't so much trial critique, just telling us what landed and what didn't. And I found that extremely helpful. I would be open to doing that. But if there's a lawyer who really needs some help, I would be interested in doing that, or I might call Linda and ask her to give this lawyer a little assistance.
Okay, so that's good. Lastly, when I started out, the first 3, 4, 5 years, I did court appointed work. And I always felt like the bail situation, this is a long time ago, the bail situation, whatever the assistant DA recommended, more often than not, the judge would, okay, well, we'll adopt that. Sentencing, same thing. You gotta understand, I like. You've been in the criminal defense business, I don't know, 20 years, give or take. So I assume you're not gonna be, you're gonna be more, you're not gonna be blindly agreeing with the prosecution on their recommendations for bail and sentencing.
I don't blindly agree with anyone on anything, certainly not someone in the courtroom. The bail rules have changed a lot since the Brangen opinion, and I would follow those carefully. I also recognize that people who are on release tend to have better outcomes when their case is resolved. So I really would not impose bail, holding someone in custody pre-trial, unless I really felt like there was no better option for them.
If I don't have any further questions, I think you're going to be a great addition to the Superior Court.
Thank you, I appreciate it.
Thank you. Councilor DePaul.
Council.
I was going to call on the people present.
A couple of words.
People present.
I believe our rules call that we call in order and I'd be after Councilor Iona. And I
Counselor,
if I could go in order. I
Counselor,
only have a couple of comments.
excuse me, Counselor, I was in respect to the people present. I was going to call on them first. So go continue. You can continue. Thank you.
Okay, just a couple of. First of all, thank you for applying. I think you're an outstanding nominee, number one. Number two, I really appreciated your comments about Judge Turner. He was certainly one of my heroes. He recently passed, as you know, which was very sad. I appeared in front of him countless times like you did, and he was just an outstanding Superior Court judge, probably the best one I've ever been in front of. If you are 1/10 of the Superior Court judge he was, you'll be superb. I'll be voting for you next week. Thank you very much, Madam Chair.
Counselor.
Did you want to continue? It's fine. You're on. Okay. Can I continue with the people that are present? Thank you. Counselor DePaula?
Thank you, Counselor.
Okay.
Good afternoon.
Afternoon.
I want to start with something that was in your application that I had flagged and that you mentioned in your opening statement. So in talking about discretion around sentencing, you said we want to avoid a sentence so lengthy, or you wrote, that they are a deterrent to accomplishing the goals enumerated, and you iterated that in your statement. What would make something, well, how would a sentence be how would a lengthy sentence be a deterrent to the goals of public safety, rehabilitation, accountability?
Well, the
Deterrence.
sentencing are not ones that I made up. Accountability, deterrence, rehabilitation, public safety. Those are the enumerated goals in sentencing. There's federal statutes that lays these goals out, 18 USC 3553, and I haven't found a Massachusetts equivalent, but I'm working on the assumption that it's the same.
Right.
Deterrence is a tough one. The thinking behind it is, if somebody gets a 10-year sentence for robbery, then everyone else will think twice before they commit a robbery, and the individual themselves will not commit the robbery.
Is that a sound theory?
I don't think so.
Why not?
Because we wouldn't have any more crime if that was a sound theory. I think it works on some people. I have certainly had older clients, let's say, coming in on a firearm licensing issue, saying, when I was 22, I did 3 months at Billerica and it straightened me out. I don't know if a lengthy state prison sentence would have accomplished that goal. And that's essentially what Chernoff said. He was the parole commissioner, and he saw that the sentences can be so long that it undid the goals of sentencing.
But so to put a point on it, how would you describe how it undoes the goal of sentencing? I mean, what about the sentence makes it worse? I understand what you're saying. It's not always effective, but why?
If you have someone who has experienced considerable trauma in their life and you put them in a prison for a long time where they're under a constant state of hypervigilance, they're probably going to come out worse than when they came in.
Can I pause there and ask you something? So I don't want to presume anything. You've had occasion to visit our houses of correction and our DOC facilities. And so you describe a environment of hypervigilance there.
Not at all places.
Not at all places. Is serving time there a trauma in itself, in your opinion?
Not for everybody.
No, okay.
I have clients who've popped by my office after a sentence and they sort of seem the same to me. But I've also had clients who came out of custody, and I'll run into them going into the probation office who are completely wrecked. So it depends on the person. And I think that the common thread for the people who struggle are people who are vulnerable. Trauma histories, small stature, gender nonconformity, things like that. Those are the people that I'm most concerned about when they go into custody, because I know that their sentence will be harder to serve than someone who doesn't have those issues.
Is the implication I should infer that such folks would receive lesser sentences from you as a judge?
Not necessarily. It would be a consideration in my sentencing.
Okay.
So
on that point, are you familiar with the state's sentencing guidelines
yes.
at all? And so in the mitigating circumstances that they enumerate in their appendix, there's several things listed. I want to talk about age in a sec, But one is that the defendant's criminal history category overstates the seriousness of the defendant's prior record. A, have you seen that in your practice? And B, what does that look like? If the criminal history is there, then how is it overstating? It is what it is.
I'm mindful when I have a client who perhaps is a person of color who grew up in an over-policed community. So even though he has a half a dozen arrests or convictions out of the BMC, maybe that overstates his criminal history because of the over-policing. So that's something that I would think about. And if the
Can I ask you a devil's advocate question? Because I do agree. Does the absence of a criminal record indicate an understatement of criminal activity? So if I have a privileged suburbanite kid coming in and they have no record, how do I know that's not an understatement of their criminal?
I wouldn't speculate on those things. If the prosecutor was able to show that it's an understatement, I would listen, but I'm also very reluctant to make assumptions about someone if there hasn't been a formal conviction or finding by the court.
Okay. And another mitigating factor that the sentencing guidelines suggest is the age of the defendant at the time of the incident or the underlying behavior. So you mentioned to me, and you alluded to a bit in your application, some reference to brain science and the way it's interacting with our courts these days. How would you describe the way that brain science should be interacting with our courts? And do you see anything developing in the future, perhaps, around the jurisprudence that's come down on that?
I appreciate your interest in this subject, and I'm not surprised given your background as an educator and working with youth who've been subjected to trauma. Age is always a factor that I would consider in sentencing. I'm very familiar with the Yachenko and Mattis decisions, although Mattis is obviously the one that plays in the Superior Court. I've read the rulings, I've read the transcripts of the hearings, I've read the affidavits presented by the experts who convinced Judge Ullman to rule as he did in Mattis. And I think that is something that I would expect every lawyer to raise if they were sentencing somebody who was in that emerging adult age bracket.
So one of your references was Judge Ullman, and Judge Ullman wrote the findings of fact for Mattis, as you alluded to. And in that finding of fact, as well as in the Mattis decision by the SJC, they go out of their way to indicate that the evidence they're looking at, the expert testimony they're looking at, covers a defendant up to the age of 20. But that science suggests that was not relevant to the record of that case, that really we're looking at 25. And science would suggest if we get there, that childhood trauma would further exacerbate or further delay that development. So I'm wondering, if someone comes before you and you're in a sentencing position and they are 22 instead of 20, are you going to give them life without parole if that's what the conviction calls for? Or are you going to say the logic of Mattis based on, let's say the defense attorney does present that science? Nope, we're not doing that.
So life without parole.
If there's a situation where the underlying conviction is, yeah.
If the sentence is mandatory, there's nothing as a trial judge I can do about it. I can sentence him to great sadness.
So if the defense presented the evidence of brain development that simply iterates what the SJC has already accepted, but expands it to the age we know, you wouldn't be inclined to follow the SJC's reasoning.
I don't think that I have the legal, or I do not have the legal authority if it's a mandate, if the sentence.
What would be the consequence of you refusing to issue life without parole?
The sentence would get flipped by the higher courts. If it's a mandatory sentence, I can't I mean, in juvenile court, there's legal authority, but as things stand now, I couldn't do it. I wish I could. I can certainly impose, I would certainly take those considerations if it wasn't a mandatory sentence. But with.
How would that play out? Because we haven't really seen that in the decisions yet. We've only seen life without parole. I mean, how would the brain development impact other sentencing?
If I had a person being sentenced on an armed robbery who's 22 years old, and the lawyers presented an argument consistent with Mattis, perhaps even a independent forensic evaluation by someone who can really speak to this person's decision-making, maturity, and trauma history, I would factor that very heavily into sentencing if I have the authority to do that.
Okay, thank you. I have no further questions, Counselor.
Mr. Jacobs.
It's good to see you. Thank you for driving out to Western Mass. I really enjoyed the conversation that we had, and we talked about many, many, many things. I will say that I heard from our recently confirmed district court judge, Greg Keren, who overlapped briefly with you at the Lowell CPCS and spoke incredibly enthusiastically about you and endorsed you. Comments that I take to heart, just about you know, how you are as a person, how you are as a colleague, the generosity of your time and advice and mentorship that you give. So I just want to share that as a thank you. Having heard that, it really landed with me in a way that was significant. Remind me, is this the first time you've applied, or?
Yes.
Okay, and can you just articulate what motivated you to want to be a judge?
What motivated me was reaching a point in my career where I started paying less attention to the lawyers and more attention to the judges, and kind of trying to understand their thought process when they ruled on complicated issues, especially those that went beyond the law. On a motion to suppress, there's a legal precedent. When you're dealing with something like sentencing, you're going well beyond what the law offers. So as I started catching myself doing that, I started thinking of myself in those shoes. And the more I thought about it, I thought, okay, maybe I could do a good job with this, and put in my application.
So how would you describe how you believe your addition to Superior Court bench would be additive to the court? And what, if anything, would you hope to be able to affect change around, or innovate around?
In some respects, I have a very different background than other lawyers other judges on the Superior Court, as an openly lesbian woman, and also as a defense attorney. There's relatively few people with those characteristics and backgrounds. And I think that there is always something to gain by having people with different backgrounds and different perspectives on the Superior Court or any courts. So that's, I think, what I bring on a more general level. As a defense lawyer, you may have picked up from my personal statement, I've just seen so many people fail. I would be very interested in seeing how we can do better for especially the young people. In our conversation in Springfield, you told me about the Emerging Adult Court of Hope. It got me pretty excited. You described it to me, and I thought it was too good to be true. And then I went home and researched it, and yes, it is. These are adults or emerging adults within that under 25 range, who are convicted, do a very intensive probationary period, and a long one, with probation department, DA's office, and ROCA, which is an anti-violence and reentry program. And if they successfully complete it, their conviction is dismissed. That was the part that I didn't actually believe was told me that. I don't know how often people in the superior courts get opportunities like that, but I'd love to see if that was possible. I could see there being resistance that these cases are too serious, but what about a superior court defendant who maybe the felony with sole superior court jurisdiction gets null prossed and they're pleading guilty to a B&E or a assault and battery? Maybe these options are available for them. But any kind of reentry services, and reentry doesn't just mean from custody, just getting out of court, supervised probation beyond what just checking in with your probation officer could potentially break the cycle. And I've had a lot of clients do extremely well at ROCA and UTEC, which is the Merrimack Valley equivalent. I'd love to see more young people going into programs like that as part of their probation period.
Appreciate that. Yeah, fully agree. Share that. I don't really have many more questions for you. Your letters of support really you had some people offering endorsements from a sort of a broad range, and I appreciated the consistency of how they talked about you and why they're excited for your nomination. So I'll leave it there, but thank you very much.
Thank you. Councilor Ferreira,
Yes, can you hear me?
you're on.
Thank you. I had a long conversation with the nominee, and I just want to say I appreciate all the work that you've done. I appreciate that you applied, and I extremely appreciate the Judge Chernoff comments. He was a friend, and I was a law clerk for him 30 years ago, and he's been an incredible friend to so many lawyers. So I appreciate your admiration for him and bringing him up, and I look forward to voting for you next week.
Okay, thank you. Before I ask you questions, I wanted to just say this to the public that are watching on YouTube, that I've been trying continuously, and I am listening to your phone calls, and you have asked why we don't see the counselors. We have 3 counselors present. I want to apologize, Councilor Iannella, Councilor Kennedy, and Councilor Jacobs, that the people at home can't see when they're asking questions. And I continually ask why, and I'm not getting an answer, but I want people out there, I'm not ignoring you. A tuxedo with brown shoes. I'm sorry, I'm not getting anywhere with it. And I agree, there's not a committee that doesn't show the people that are speaking. So I'll keep speaking out for you. So I just want you to know I'm not ignoring you. So welcome. And thank you for all the time that you afforded me. It was really a pleasure. But I got to tell you personally, I'm very disappointed that your daughter couldn't make it, because I saw a picture of her daughter and she's a clone. I can't believe that. It's incredible. So having said that aside, my colleagues have asked very good questions, and I'm very concerned about disabilities. And I don't think we have enough judges that have been involved with disability. And in my little way, I served 22 years on the Commission on Disabilities. So I want to know your involvement in disabilities for the public to know.
I appreciate your interest in litigants with disabilities. I have represented quite a few individuals with disabilities, both visible and invisible. With people with visible disabilities, there's building access and huge problems in the jails. I've had a couple of clients. I'm thinking of one who was paraplegic, and his conditions of confinement were just unacceptable. And I was calling the jail very often, but they really could not provide him what he needed. He needed sort of a hospital setting. As far as invisible disabilities, those are close to my heart. I've represented quite a few individuals on the autism spectrum. And there is a lot of misunderstanding of them. There are police interactions that go bad. There's interactions in court that where people don't understand why this person is behaving the way they do. Often behavior that really is stimming is misunderstood, and they think that they're doing something weird or bad. So it's something that I have experience with, and I think it's important that as a judiciary and in the court system, we try to educate ourselves to make sure we're serving them the best we can.
Thank you. I think that's very important to bring to the court, because you have to have an understanding. If that person doesn't have the ability to speak clearly, or whatever gestures they're making, that it's not misinterpreted and it's respected. So I like that you've done that. Now, I want to ask you about minimum mandatory, and I know my colleague, Councilor Iannella, shares my concern about that. And why don't you tell me, and then I'll tell you why.
You're asking me how I.
Yeah, what's your opinion?
I don't like mandatory minimum sentences ever. I don't think that a one-size-fits-all solution is really a solution. So I wish that there weren't any mandatory minimums. I think that some consistency in sentencing is important, and that's what discretionary guidelines can do. But many of the most tragic outcomes that I've had in cases have involved mandatory minimums where the person just didn't deserve to have the kind of sentence that was imposed because of mitigating circumstances. So if I could rewrite the law, I would get rid of all mandatory minimums otherwise, but obviously I have to impose them if they're required by statute.
Well, I'm personally against it, and I'm not a lawyer, but I saw it firsthand as a counselor many, many years ago. And we had a man before us, probably 56 or 57, and seeking a pardon. And wonderful man, and had gone through a lot in health-wise. He had cancer, had a leg removed, he's a lot, but he's very involved in his community, a loving husband and father. But when he was 17, he was on his way to school. And an older friend, 21 years old, stopped him and asked him if he'd do a favor. And he handed him 5 bags of marijuana. Here's a naive, gullible, honest kid, good student, good son. Everybody liked him. He wanted to please his older friend. So he took the 5 bags, brought them into school. He sold one. When he tried to sell the next one, that student reported him to the principal, and they went to his locker and found the others. I might be wrong, but I think when that started, the minimum mandatory, it was 4 years, and then it changed to 2. So up he went to prison. He had a scholarship. He was going to play football. So there goes the prom, the dances, his youth, everything was gone. And so when he came out, fortunately, he got a job as a custodian in a private school. Guess what? Now that school is closed. So when you think of someone that age, had enough to get a job, but the burden of being in prison. So, you know, I think of him and I think how unfair that was. How unfair that I just have to believe that whoever that judge was, if he or she had the discretion, that wouldn't have happened. You know, and I think of him so often. So that's my experience with it. So I really am opposed. Has it changed at all through the years?
Well, school zones have been repealed, and school zone enhancements for drug distribution. I think that, or my understanding is that the motivation was that it disproportionately impacted people of color who are more likely to live in dense areas, so they're more likely to be within however many feet of a school. I still see them being imposed in federal court, and it feels very bad. Okay.
Well, I always look to see if a nominee has writings. Majority don't, but you do, and something that I think they're very timely. And your title was Trying Drug Cases in Massachusetts. And you know, we look back at Dugan and that travesty of justice that we can never remedy. Tell me about that, tell us about the writings.
That was a chapter in one of the MCLE course books, trying drug cases in Massachusetts. I believe that I wrote the chapter, it was quite some time ago, about how things are changing based on new development in areas of law.
So you like to write, and that's key to go to the Superior Court. You have to like to write. So you're asked to put a sample. So tell us about that sample case that you put.
Yeah, I submitted a portion of an appellate brief that I submitted some years back. Had an oral argument, we lost. That is usually what happens in the appeals court. The issue there was a jury instruction on. It was a parent, among other things, accused of assault and battery for hitting her daughter in the face. And there is case law, SJC case law, that talks about under what circumstances that there can be an affirmative defense of lawful disciplining of your child. And my argument was that the judge's instructions were confusing, and it left the jury in a place where they convicted without properly understanding what this affirmative defense was. And we were not successful.
So when you look back at all your cases, about how many have you had?
In my whole career? In the high hundreds.
Okay, when you look back, is there one that always stays in your mind that was the most rewarding, and you look back and you smile about it?
It's hard to choose one, but let me do that. I had a client in federal court charged in a drug conspiracy. No record, no nothing, but he was essentially a mule, which means he was given a package and take it from point A to point B. The amount that was attributed to him was very high, so he the guidelines for his sentencing was very high. I went through, because this is a federal case, we got recordings of all kind of phone calls between my client and other co-conspirators. And I found recordings of him begging his handler to give him packages to deliver because his wife was pregnant and he couldn't support her. That they were starving, that they were eating hard-boiled eggs. And I was able to use that as mitigating evidence in front of Judge Woodlock to show that he did not deserve to have a guideline sentence. And also that he didn't know what he was delivering. It could have been 10 kilograms, it could have been 8 kilograms, it's whatever they gave to him. There also was the issue that the baby was born while the case was going. Fortunately, he was out of custody. And the mother had such serious mental health issues that she couldn't care for the baby without him. And I got letters and documentation from her medical providers, essentially saying that the child would go to foster care if he was no longer in the picture. She would be unable to care for the baby alone. And he had 1 day of jail credit and went in for sentencing, and Judge Woodlock gave him a time served sentence. So he walked out despite being convicted of conspiracy to possess with intent to distribute 8 kilograms of cocaine. I was in touch with the family for quite some time. I used to send them diapers, just to help them get by. And I think about them all the time. That was a good judge doing the work.
Well, I'm going to, I want to tell you, you've got nice letters from people with really exceptional things said about you, so I wanted to put them on the record. First of all, I got a letter from Amanda Rowan, Attorney Rowan, and she said, they're also lengthy. I wish I could read them all, but we'll be here till midnight if I did. So anyway, and she wanted to say how she's known you for several years. And during her time that she was assistant clerk at the Lowell Superior Court. And that you're a joy to work with. And she personally witnessed your interaction with others and your relationship with your colleagues and on the criminal defense bar and the members of the Middlesex DA's office, that you are kind and professional while dealing with the court and takes a genuine and personal interest in the lives of members of the court staff and others. So that is one. Now, the other one is Joseph Maloney. And he is the assistant clerk of courts for 32 years. And he said that in his 32 years as an assistant clerk of the Superior Court, I can honestly say Keren stands out as one of the most respected and well thought of members of the bar. I gladly and humbly recommend her appointment to the bench, and at the risk of sounding hyperbolic, this commission will look back on her appointment as one of the best decisions they have made. So as your district counselor, I appreciate that comment. And it was a very, very nice letter. Now, the other one is Allison Cartwright. And she has had experience as a trial attorney, 30 years, I'm sorry, 30 years, I'm adding a little more. I'm giving you 2 more years. And I wish I could read it all, it's a beautiful letter. And she says she's known you for more than a decade, and you're a remarkable, thoughtful, insightful, caring person, and committed to ensuring that our laws and legal systems protect the rights of the people in a fair, equitable, and just manner. And she said that your legal skills in state and federal courts, remarkable. You excel in representing clients, both civil and criminal. And she said she wholeheartedly asks that we support the nomination of Keren Goldenberg to the bench of the Superior Court. Thank you. Now, Stephen Evans, okay. Stephen Evans from Belmont, and he wants to weigh in to say that in this past year, you have represented his son, who had an invisible disability, autism, and was falsely accused of a crime and arrested by career law enforcement officials with decades of experience who should have known better. Keren was a compassionate and skilled advocate for my son and ultimately had the case dismissed. That's remarkable. So she goes on to say that the Commonwealth elected not to refile changes. And so she's saying that you understand mental health. That's important to me, and I know to the counselors, and to evaluate. And even though his son's college application essays put together a record to present to the prosecutor handling the case, they elected not to refile the changes. So he says you bring a deep understanding as to how people with disabilities particularly invisible disabilities, are vulnerable to false accusations and mistreatment by the criminal justice system. So that's a beautiful letter too. So I think that, concludes the letters, but each of them were heartfelt, and these will be on our file, and all of the councils will have a copy of that. So having said that, it is a pleasure meeting you. You gave me hours, and I like to meet because I'm voting for the whole person, not someone coming in here and looking at papers and looking at you. And I want you to know you're on the official Hall of Fame for the Belgian waffles, okay? And that's with Judge Hines, Judge Gantz, and Judge Island and so many others, but they don't have room on that wall to put all the names up. So anyway, but thank you. I really appreciate all that time that you took to see me. And I appreciate all the people who came here in support of this nominee. And I will be presenting your name next Wednesday at the Public Assembly when the Lieutenant Governor presides, and the council will be voting, and I'd be very proud to present your name. So thank you all for coming.